Hi everyone, and a warm welcome. My name is Andrea Resti, and I have the pleasure of leading the Norwegian Savings Banks Association. Thank you for taking the time to join us today. We are here to discuss a topic that is both technical and deeply important. The future of the Norwegian equity certificate, a key part of our banking model for more than 30 years. The equity certificates represents a sophisticated financial innovation. It has enabled savings banks to access capital markets while maintaining their distinctive identity and purpose. This structure has created a long-term balance between modernization and tradition, providing capital without compromising values such as local presence, broad ownership, and long-term community focus. In doing so, the equity certificate has helped shape a banking sector that is both resilient and deeply connected to local economic development. About 3 years ago, the European Banking Authority raised concerns about whether this structure fully meets the requirements of the Capital Requirements Regulation, the CRR. The Norwegian Ministry of Finance followed up by appointing Sparebankutvalget, which delivered its report in November last year. While the committee recommended legal changes, their reasoning differs from EBA's. It is also important to note that neither the committee nor the banking sector has had the opportunity to engage in direct dialogue with EBA about these concerns. And as a result, we still have very limited understanding of the reasoning behind EBA's conclusions. And based on what we do know and how we understand CRR, many of us, including the Norwegian Savings Banks Association, Finance Norway, and several others, still have a different view. We believe the current structure fits well with the goals of the CRR, and that making changes could create uncertainty and lead to unintended effects. Today, we are fortunate to welcome 3 highly respected experts, each of whom will bring valuable insight into this discussion. First, we will hear from Professor Andrea Resti from Bocconi University. Professor Resti is one of Europe's leading experts on banking regulations and supervision. He has served as a policy advisor to the European Parliament, as vice chair of the EBA's banking stakeholder group, and work for European banks, rating agencies, and supervisors. He is also serving as an expert witness in major financial cases. Then we will hear from Mikael Engelhard, Head of Banking Supervision and Policy Issues at DSGV, the German Savings Banks Association. DSGV represents more than 350 independent institutions in Germany, forming one of the largest banking networks in the world. And Mikael, he will have to leave us at 13:10 to attend a meeting in the EU Parliament, so he will not attend the Q&A session. And last but not least, we will hear from Ines Scacchi. She is head of the regulatory affairs at ESBG, the European Savings and Retail Banking Group. Ms. Scacchi is a European regulatory advisor with broad experience in banking law and regulation across Italy, Europe, and the United States. And today she focuses particularly on the regulatory policy and compliance issues in the financial sector. And of course, we are pleased to welcome participants from the ministry, regulators, the legal community, and many of our own member institutions. There will be time for questions and comments after the presentations, and we hope today's session will be both insightful and constructive. So with that, I am pleased to give the floor to Professor Andrea Resti. Please, Andrea.
Thank you very much. Let me share my presentation, and I hope you can see it. Well, good morning, and thank you for attending this workshop on equity certificates and their eligibility as CET1 capital. Let me just advance my presentation. Okay, good. My name is Andrea Resti, and thanks to Teresa's kind introduction, I can skip this slide in the interest of brevity. My talk will be organized as follows. We start by reviewing some features of equity certificates, and secondly, we recall the main European rules on CET1 eligibility. Then we turn to the debate surrounding equity certificates and to the concerns that have been raised by the EBA as well as by the commission that was created in the past months by the Norwegian Ministry of Finance. I will then present my opinion on these matters, drawing on a written document that I have produced in the past weeks for a group of Norwegian savings banks. And the last part of my presentation will be dedicated to the risks that might originate from a change in the rules on equity certificates. So to begin with, let's have a look at some key features of equity certificates. Although I understand that most of you are already familiar with them, it is useful to recall them briefly in order to introduce the debate on equity certificates that has been going on during the last 3 years. Equity certificates, in short ECs, are financial instruments. They are sold to investors and they allow savings banks to raise equity capital on the market. They have voting rights, as you know, but those voting rights are kept at 40%, so they cannot have a majority in the bank's general meeting. They are part of the bank's equity capital together with its so-called primary capital, that is the capital that the bank had in place before issuing ECs, plus retained earnings. Equity certificates are part of the bank's owner capital, the share of capital that is owned by external investors, whereas primary capital is part of the bank's ownerless capital. Is everything okay on your side? Okay, no, because I heard the sound, but if it is okay, I will continue my presentation.
It's fine.
Okay, thank you for the feedback, because I just heard the bell ringing and I thought it could be some technical issue. Okay, so let me go back to my presentation actually. And so what I was saying is that primary capital is part of the bank's ownerless capital. That is capital that belongs to the bank itself. The two also include a premium reserve and a compensation fund that are fed by the premium paid by investors above the certificate's face value, and owner capital, just like ownerless capital, may also include retained earnings, whereas ownerless capital also includes a donation fund set aside in view of future donations. Owner capital and ownerless capital need not be equal in size, and actually the ratio of owner capital to total capital is called the ownership ratio. Before I leave this slide, it is important to emphasize that ownerless capital has no owners, no investors holding it, as it was also clarified by the Norwegian FSA in a document sent to the EBA. Let us now consider how profits are allocated. Starting from the top, you have that a portion of the annual profits gets allocated to the bank itself and may be used for socially oriented purposes such as donations, either directly or through a foundation, or payments to customers aimed at making the net cost of banking services cheaper. Part of the earnings may be retained, in which case they increase the bank's primary capital, which is part of ownerless capital. The rest of the bank's profits are allocated to owner capital, with the allocation being based on the ownership ratio. And they can either be retained, in which case they accrue the equalization fund and the bank's owner capital, or they can be distributed as dividends to private investors. The increase in ownerless capital and in owner capital should be such that the ownership ratio remains roughly unchanged. Now, an important question is, should the socially oriented payments that are made by the bank be considered as dividends paid to some shadow investor? And this is relevant because savings banks themselves have been using the word dividend to call, for example, the donations made to their customers. But the answer is no. Those are no dividends. There is no shadow investor. And again, it is worth looking at what the FSA says on this. The return on ownerless capital, if not retained, can only be given as donations to non-profit purposes. Let me now come to a crucial issue, the way that ownerless capital and owner capital are used to cover losses. The first losses are covered on a pro rata basis by primary capital, donations funds, and equalization reserve. If losses are higher, then the compensation fund and the premium reserve are used. If those are not enough, then equity certificates may be wiped out. And as you can see, the green items, that is ownerless capital, somehow act as a cushion, protecting EC holders from first losses. Ownerless capital basically consists of retained earnings, just like the reserves posted in the balance sheets of large European banks. And this chart gives you an example using 2023 data for Banco Bilbao Vizcaya Argentaria, Deutsche Bank, and BNP Paribas. The green bars are basically reserves built through retained earnings, and they are eligible as CET1 capital, just like ownerless capital. When there are losses to be covered, it is usual for banks to use these reserves first, leaving the value of common shares unchanged. And this was done, for example, by Deutsche Bank in 2019. And the fact that reserves were used to cover losses first without affecting the value of common shares did not lead supervisors to claim that such reserves or common shares themselves were not eligible as CET1 capital. So, what are the requirements to be met in order for an equity item to be eligible as CET1 capital? In the European Union, as you know, those rules are stated in the CRR, the Capital Requirements Regulation, and namely in Part 2, Title 1, Chapter 2, Section 1, which is dedicated to CET1 items and instruments. And to be precise, all eligible CET1 components, CET1 items, are listed in Article 26. As you can see, there are different items listed from A to F. Some of them, and I refer mainly to letter A, are also capital instruments issued by the bank, whereas other items, and I refer to letters C to F, are capital items but are not capital instruments. Capital items that are also capital instruments, that is, financial instruments issued by the bank, must comply with a set of requirements that are listed in Article 28. The most significant requirement listed under letter I involves a comparison between CET1 instruments and other capital instruments and requires that, compared to all the capital instruments issued by the bank, CET1 instruments absorb the first and proportionately greatest share of losses, and each instrument absorbs losses to the same degree as all other CET1 instruments. This requirement does not involve ownerless capital because, and I quote the Norwegian FSA here, there are no capital instruments issued in relation to the ownerless equity, and ownerless capital is not a capital instrument. Let us now go back to the list in Article 26 and let us look at the CET1 items that are not capital instruments, that is letters C to F. Those other items are also subject to a requirement that is stated by Article 26 itself. They can only be recognized as CET1 if they are available to the institution for unrestricted and immediate use to cover risks or losses as soon as these occur. This requirement, unlike the one in Article 28 that we saw before, is the only one that is relevant for ownerless capital. Again, I quote the Norwegian FSA here. Ownerless capital is a capital item. It is not a capital instrument. To recap, CET1 items that are also capital instruments must comply with Article 28, including the comparison under letter I that only involves other capital instruments and therefore does not relate to ownerless capital. Ownerless capital, instead, must comply with the requirement in Article 26, that is, it must be available to cover losses in an unrestricted and immediate way. Against this backdrop, let us now consider the concerns raised by the EBA and the commission created by the Norwegian Ministry of Finance. As far as the EBA is concerned, in a letter dated June 2022, the authority said that equity certificates may no more qualify as CET1 capital in the future because they do not comply with Article 26 and Article 28, letter I of the CRR. And this position has never been explained in detail, at least not openly. But the EBA seems to believe that ECs do not comply with those articles because, as we have seen, ownerless capital may absorb the first and greatest portion of losses. Before I tell you my opinion on the EBA's concerns, let me briefly recall some warnings that were issued by the Commission created by the Norwegian Ministry of Finance. First, it has warned that by ignoring the EBA's concern, one could trigger a legal procedure and a long-lasting uncertainty. Secondly, it has voiced a concern of its own, which, to the best of my knowledge, was never raised by the EBA. That is, that equity certificates are different from the ordinary shares of a joint stock company because they do not have rights to all the equity items of the bank. And I will get back to this concern in a moment. As a result, the Commission is proposing a regulatory change whereby equity certificates and ownerless capital would cover losses on a pari passu basis, that is, at the same time. Under this new regime, equity certificates would lose any loss protection and therefore would become considerably riskier than they are today. And yet, to my surprise, the Commission claims that this would not trigger any adjustment to compensate the EC holders, for example, by granting them with higher voting rights. Let me briefly express my point of view on these matters now. First, we know that EBA is concerned that ownerless capital may violate Article 26 of the CRR, the one that requires that CET1 capital be available for unrestricted and immediate use to cover risks or losses. In my opinion, I have gone through all the legal provisions in the Norwegian banking law, and I have checked whether ownerless capital might somehow flee the bank, escape from the bank without a specific supervisory or judicial approval before it can be used to cover losses. And the result is that it simply cannot. If the EBA believes that some of these provisions are unclear, they could be, of course, be further clarified, but no major change is needed to ensure that ownerless capital is promptly available at all times to cover losses. So we can tick the first box. Article 26 is okay. The second concern relates to Article 28. And since we have already discussed that article, you know what I'm talking about, it requires that CET1 instruments have sufficient loss-absorbing capacity. But it would be unfair to say that this requirement involves any kind of comparison between EC and ownerless capital. Article 28 requires that CET1 instruments have sufficient loss-absorbing capacity, but does so in a very precise and specific way. It only involves a comparison with other capital instruments, and therefore it asks for no comparison with ownerless capital and its components. And in fact, as noted above, the FSA tells us that there are no capital instruments issued in relation to ownerless capital, and what is more, even the commission created by the Norwegian Ministry of Finance has stated that pretty clearly. If you look at their report, they say that savings banks have not issued other equity instruments than equity certificates, and even that equity certificates absorb the first and proportionately largest share of the loss compared to other instruments issued, in line with Article 28 of the CRR. So we can tick the second box as well. Article 28 is also okay. Now, talking about the Commission, I mentioned that they are concerned by the fact that equity certificates, unlike common equity in joint stakeholder companies, do not have unconstrained rights to all the equity items of the bank. And to cut it short, this is true. EC holders only own owner capital, whereas ownerless capital, as we have seen, is held by the bank itself. But my problem here is, how does this fact contrast with any of the requirements laid out in the CRR? No one has ever explained why this should be the case. And indeed, the fact that some capital instruments may imply a limited claim on the equity of a savings bank is explicitly foreseen by the CRR and other EU regulations. My first example on this slide is Article 29 of the CRR, which explicitly provides for the possibility that savings banks issue capital instruments whose owners, in the event of liquidation, are entitled to a limited claim on the institution's net assets. So such limitations are legitimate. And my second example is Regulation 241/2014, drafted by the EBA itself on behalf of the European Commission, where it says that savings institutions may issue CET1 instruments which only benefit from the bank's reserves to some extent, just like equity certificates do. So the fact that access to reserves is constrained is perfectly acceptable. To conclude, Equity certificates do not have rights to all the equity items in the bank. This is true, but this is also totally legitimate. When you read this kind of reservations, it occurs to you that someone may believe that all banks were created equal, and that the only type of bank that should be allowed by legislators is a profit-oriented bank that is structured as a joint stock company. And this leads me actually to the last part of my presentation. Of course, many banks are joint stock companies and aim at producing profits for their shareholders. In the banking jargon, they are called shareholder banks. But they are not the only type of bank that you find under the sun. Actually, in all countries, under all latitudes, you also find a second type of banks, like savings banks, which aim at producing benefits for a broader range of stakeholders, including employees, customers, communities, and of course, possibly investors who choose to participate in the bank. Economists have shown that such stakeholder banks present a number of advantages vis-à-vis shareholder banks that are focused only on short-term profitability. And I don't have time to recall all these results, which I'm sure will also be covered by my fellow speakers. So let me just mention the last one. It has been shown that although stakeholder banks have their own vulnerabilities, the fact that a banking system includes both shareholder and stakeholder banks increases its resilience to external shocks and its ability to keep supporting families and companies at times of economic slowdown. I believe that by removing the cushion of ownerless capital that currently protects equity certificates from first losses, the reform proposed by the Commission might trigger a domino effect and lead to serious unintended consequences. First, a sudden change in the status of equity certificates might trigger mass litigations, and, well, that would indeed be a source of legal uncertainty. Disaffected investors might also leave the market altogether, leaving savings banks without a fundamental source of new capital. Or, to stay in the market, investors might ask to be compensated through higher returns, but that would leave less money for social uses and lead to higher costs for customers. Or investors could ask for greater voting rights, leading to a removal of the 40% cap and making savings banks very similar to joint stock companies. This kind of process has already happened in the past, leading to wrong results. Indeed, the case of British building societies provides a powerful memento. In 1986, a law was passed to allow British building societies to convert into joint stock companies. And in the 90s, most building societies were demutualized, with ownerless capital being converted into common equity and often sold to larger banks. This caused a huge transfer of wealth from future members and future communities to current members, who benefited from a £35 billion windfall profit. Studies have shown that this led to a remarkable lack of biodiversity in the banking sector and made the UK more vulnerable to the 2007-2009 great financial crisis. And actually, Northern Rock was just one of the many demutualized banking society, and as you may remember, it lay at the center of the UK financial disaster. Time is tight, and I don't want to take too much time from my fellow presenters. Actually, I'm looking forward to listening to them. But if I were to summarize in a nutshell the main messages that I would like to get across today, they would be the following. First, No one has ever shown that EU rules on CET1 capital require equity certificates to take losses on a pari passu basis with ownerless capital. Second, Norwegian policymakers may certainly decide to make savings banks more similar to joint stock companies if they believe that this is appropriate, but this would be their own choice and would not be driven by any compelling legal argument regarding CET1 eligibility. And third, if such an avenue is chosen, then everybody should be aware of its possible consequences. This is my bottom line, although of course you will find more in my written opinion. I guess I have to stop here, and I thank you very much for listening.
Thank you very much, Andrea Resti, for your clear presentation. I think we'll just proceed with the next speaker. So Mikael Engelhard from the German Savings Banks Association, please.
Yes, thank you. Thank you very much, Therese. Thank you, and hello to everybody. If I'm correct, the audience is quite vast, so the topic is important, which is great to see that the interest is so high in such an important issue. Not only, to be frank, for the Norwegian savings banks, but also for the whole savings banks community all over Europe, because the discussion is going into the substance and the core of what is a savings bank. And it's not only in brackets somehow, not only about capital instruments, it's about the business model and the future of large parts of the savings bank sector. So thank you very much for having me here today and having the opportunity. It's an honor and a pleasure to try to contribute the view of one part of the savings bank sector in Europe, the German savings banks. And I would like to do that in two parts. First of all, just to give a short comment on what Professor Resti has just shown us very clearly, and in I think a very good manner, what is the substance of the topics and where the legal obstacles are, and having a second part on what I see as a major advantage and role of savings banks, and why we very strongly believe, and that for more than 200 years now, at least, concerning German savings bank, why the business model of savings bank is so important for citizens, for economy, and for Europe in total. So just briefly commenting on what you, Professor Resti, said, to put the main message at the beginning of my short comment, we share your views and the conclusions you draw from what the legal text on EU level shows and which obstacles are now brought up by the discussions on an EBA level and on a national level. I'd like to go into the past or give an insight into the structure of capital equity, structure of German savings banks. The vast majority of the components is set up by retained earnings. German savings banks have something similar to ownerless capital in a broad, in a more narrow sense, which was issued by the initial founders of savings banks many years and decades ago. But the main source of contributing to a good capital base is done by retained earnings. So we are there in the back to the core of your explanations and your view into the CRR regulations. That's one of the parts also. And there I would shortly like to recall the discussion we had in times of the setting up of the Basel rules, especially the time where the equity side was discussed. To recall, and many of the audience here and people in the call will recall that initially the idea, and that is how now the text is drafted, the ideal world in the view of at least some market actors and regulators would be share capital. And that is how now the CRR, you mentioned the articles, now is composed, going back to the initial thought of what a share is composed and which function it has. And that, if you look at the savings bank structure, put us in a would have put us, to put it that way, in a quite difficult situation, not having shares issued, not having shareholders, just retained earnings, would put this whole business model and structure in question. So that the period, luckily, was quite short, where this matter was discussed in depth. We now have retained earnings and other items, as you mentioned, in the CRR, and they are safe, but it shows the difficulties of discussions which are undergoing here, if you especially look at an international level. Concerning the comments EBA and other, especially on the national level, made, we are very much in line what your paper is saying, Mr. Resti. We do not share the view which restricts different CET instruments in a manner as it is now questions in the different reports and opinions. The CRR, to our opinion, is quite clear. Doesn't leave much. It doesn't leave much room in both directions, but that's also to be seen in a positive way on the issue we are discussing now, because the ideas behind the CRR text are quite clear, and it should be sticked to that. So support from our side, especially because we do really see a more general discussion which is on stake if these issues are put in question here. Second part of my comments would be more on a general level to point out and it was mentioned by Therese, you in the introduction, and by Mr. Resti in his slide, which he skipped on the major features, positive features of the structural elements of the different actors on the European banking market. And it is quite obvious that not only, and that's already quite long ago, somehow the financial crisis, 2007, 2008, but more especially the COVID crisis more recently showed that a diversified banking landscape is key and a very positive aspect of the European market. Not only coming from a size perspective, you mentioned, Therese, our members are more than 340 now, and their size is going from very small savings banks, which are around about 400 million euro turnover, onto ECB, up to ECB supervised savings banks. So we, in our own network, we have a variety of institutions, which is for the network, and we are in institutional protection scheme, also a stabilizing factor. And if you multiply that on a European level, we have a diversity in size, in business models, in legal structures, which has proved to be an asset on a financial stability side in the past decades. And it would be a great risk and danger to put this or this structure into question because of some kind of interpretation of rules. Second point in this field of advantages of the banking sector we have is for sure, and Therese mentioned that in her introduction, savings banks especially, but we are not the only ones. We have the cooperatives, we have smaller private banks. They are very near to their customers. We are active in the regions, we are active with our customers in smaller towns, in the rural area all over Germany, and this is a great advantage from a side of a supply of banking services on the one side, but also on an issue which is very dear to our heart is financial literacy. And that's the case for Norway, for other countries. We're in the region and in close contact to our customers, also young customers, so trying to raise financial literacy issues also in that field. Putting into question, we are back to our topic with that, structures, legal structures, which would, in many cases, I presume, lead to bigger entities because mergers would have to be undergone, new structures would have to be found, would lead to less market proximity, to less procurement of banking services for customers, for SMEs in the regions. And I'm very convinced that we should not put that at stake in this discussion. And last point, and I will finish on that, would be, and the issue was also raised on the issue of profitability. There are different kinds of profitability, I'm quite convinced. Our interpretation of profitability is a bit different from other market actors, I would say, for sure. And I think that's normal economic thinking. Banks, being savings bank or whatever, do have to earn money. The business has to be run on the one side, but we also need to gather reserves, return earnings, and so on. So that's the core of economic behavior. But it is not to serve shareholders or others outside of the bank. It is rather serving society by donations, by sponsoring, and so on. So that's, I think, an important point to keep in mind. And I was happy to see that also in the slides of Mr. Resti on the point of donations, etc. So that's the core of savings banks, also being in Spain, in Germany, or in Norway, that we are there to serve the people and to serve society by managing banking risks and providing services to the real economy and customers. Thank you very much, and great to be here today.
Thank you, Mikael, and for sharing valuable comments and perspectives. And as already mentioned, Michael will leave us to reach his next meeting, but I hope the rest of you will stick with us. So let's proceed with the next speaker, Ines Scacchi from ESBG. Please.
I can't hear you, Ines.
I was muted. Good afternoon, and thank you for having me. And I enthusiastically joined this panel because what is at stake here is absolutely important from the perspective of our Norwegian members, but from the perspective of the European Saving Association. I don't know if I have to share my presentation. My presentation is already managed by the organizer. Please tell me, otherwise I'm going to share my screen. Okay, I will share my screen though.
Now we see it.
Okay, and so please go ahead. I will ask just the help to go through the presentation. Okay, so useless to reinforce what was already mentioned to the distinguished panelists from Michael, Professor Resti, on the importance of savings banks to maintain diversity in the financial landscape. Not really, I mean, especially this time in which in Europe there is a huge debate about the competitiveness of the banking sectors vis-a-vis to other main jurisdictions. We believe that really important to maintain both shareholder banks and stakeholder banks. So for us, it's fundamental really to point out that as a European Association, we strongly believe that altering this traditional capital framework of the savings banks in Norway would not just impact themselves, but could harm the overall diversity of the sector and with no clear view about, but I will come back to this point, to the legal consequences of this. If we disrupt this model, the consequences we will believe there will be wide-ranging and severe. And as Professor Resti already showed from the past experience, he quoted and reminded the UK experience, but I can assure you, even in Italy, and reform of savings banks was equally detrimental. We don't have a clue right now of the consequences, even in terms of a prospective litigation. For sure, the damage would be no rest only on the banks, but will pass through the communities, since, of course, as already mentioned and discussed, the important role of savings banks is not just to be profit-oriented, but give back the local community, the economy, and the stakeholders part of the benefit. So I'm going to the following slide. When the colleague from the Norwegian Savings Bank Association come to us and we start to discuss this issue, and we were not aware of what's going on, to us it was really clear since the very beginning that we need to take some actions. And ESBG took some important steps on that. We supported the action of the colleagues on seeking legal advice to respect to the specific point, because I want to stress no one never tested and challenging such assessment on judicial in the court. So seeking and having such precious legal opinion could make a big difference. Secondly, ESBG really enforce and ask all members to share with the Norwegian members the past experience, because in many countries, in many member states, in some member states, past experience really went directly to the same pattern, specifically Italy, for instance. So we encourage members to share with the Norwegian colleagues any evidence, any arguments, any past experience that they experience in their own on when the legislator tried to force the change on the legal and capital structure of savings banks. And then we start to discuss with EBA, and I can say that we were kind of optimistic about the fact, discussing with EBA about this assessment, the reason why, and we were quite surprised to engage with EBA, and even practically speaking said, we don't have a lot to say in addition to that, but I will come back to this on the next slide. Eventually and finally, as a ESBG, we supported even with the Ministry of Finance in Norway, and we support the and concur with the analysis of Professor Resti, and we point out that in our opinion, that assessment was a wrong assessment, at least an assessment in which are not really clear the legal basis. So if I go to the next slide, just 1 second. Okay, so what EBA says, practically speaking, we engage with the discussion with EBA, we exchange some letters, correspondence, and basically EBA is pretty aware of the fact that based on their assessment right now, there is in Norway a proposed legislative change on the future of savings banks. EBA is very aware, and they acknowledge that the proposed change could have a significant effect on the Norway banking Norway savings banks. EBA recall his role on this, and I want to point out that EBA has an important role here because EBA is mandated by the CER to monitor the quality of unfound instruments, including CET1 instruments across Europe, and EBA has the mandate to publish and to maintain a list of capital instruments for each member state that qualify as CET1 instrument. So in my view, EBA really have a key role on this. So heard from EBA that they said to us basically, okay, we did our assessment, now it's up to you guys, it's up to you, it's up to the savings banks to discuss with their national authorities. It seems to us a little, too little. And I want to point out this important issue because we are discussing right now in Europe on the capital markets, the perspective enhancement of redesign of supervisory structure. There are many voices that push for a really change in the supervisory framework on capital markets. We need to remind this because when you try or the discussion is to say we need, in order to advance the capital market union in Europe, we need to overcome the current fragmentation, we need more robust European centralized supervision. Well, let's put on the background the fact that then EBA, it appears say, I did my job and now it's up to the Norwegian banks to discuss with their authorities. So if I go forward with my presentation, the point that I really want to challenge, sorry, I have, okay. It's true. I want to recall that the accountability principle and the EBA role on this, because in sum, they said to us, I did my assessment, now is full responsibilities of the local authority to follow up my assessment. So in their view, they're not accountable. So, but I am personally very skeptical about the fact that EBA has no liabilities of the assessment. I want to recall that the EBA, as a banking authority, must act strictly with the mandate, respect the principle not only of proportionality, but liabilities and accountabilities. Accountability entails the obligation to explain, to justify, to take a responsibility for the decision and the activity performed, including be responsible for any damages or faults that can occur. So accountability, in my opinion, really lies with the entity exercising the power of performing the task. So it's true that the assessment was made by the authority. I expect that if there would be some judicial review of the activity and the assessment made by the EBA, the judiciary will demand both authorities, the European authority and the national authority, to explain the basis of such an assessment. So in my opinion, the fact that the EBA said to us, I don't have any role to play here because I made my assessment a couple of years ago, now I'm done, so I encourage you guys to talk at the national level. So in brief, let me conclude. In our opinion, as a European Savings Bank Association, we need really to explain and to start really to leverage and amplify the voice, not only at a national level, but at European level. Therefore, we still call, again, we invite the colleague of the Norwegian savings banks and the banks affected to try to rediscuss at the highest level possible the issue with EBA, but not only on the EBA, but even with the European Commission, based on the founding of the legal opinion of Professor Resti. I want to stress, remind once again, the accountability principle that is the foundation of the operational of all authorities in the EU legal framework. I want even to point out the issue of challenging or seeking public litigation. We all are aware of the fact that there is kind of a reluctance to go and to seek from the perspective of the banking sector to pursue public litigation to reputational risk, but the fact that for a certain number of years there could be some uncertainty about the outcome of the judicial procedures. We have some administrative remedies in the EU law, but of course, which for sure are more swift and less burdensome of the judicial review, but I need to be even I need to point out that there are some questions about the independence of this administrative body that perform administrative reviews. I want really to point out a point of the presentation of Professor Resti, that he was that if the Norwegian authority will pursue the reform, that there will be a great deal of uncertainty about possibly litigation, many litigation from holders of the equity certificate. So in any case, we are facing in a scenario in which there will be a great deal of uncertainty and possibly really severe litigation. So we really encourage once again to engage with the European Commission and with the authority itself and with authority at national level to really to consider and to have a clear explanation of the legal basis of the assessment made by the European Banking Authority. Thank you.
Thank you, Ines, and thank you very much to all our speakers. So we now invite questions and comments from the audience, and you are all welcome to raise your hands or submit a question in the chat. And my colleague Magnus, he will open the microphone for you. So please, everyone. Any questions or comments? No?
There are currently no questions in the Q&A sections or in the chat. There is also a possibility to raise your digital hand if you should wish to ask a question verbally or engage with the speakers.
So everything's clear then, I assume.
I think the presentations were so good and thorough that no questions were left unanswered.
All right.
Here we have something.
Okay.
Yes, there's a question whether we will make the presentations available for the viewers afterwards, and I believe we already have the permissions to do so.
Absolutely, yes.
Yeah, the whole webinar will also be available at our homepage.
Yes, we will publish a recording as soon as possible.
All right, so then maybe I should just round off a bit. I just wanted to say that to us, this is not just a technical debate. This is about preserving a model that has delivered stability, diversity, and long-term value in the Norwegian banking sector and for the Norwegian society. And the discussion we had here today has clearly shown that there are strong reasons to continue defending the equity certificate structure as it stands. And it is now crucial that the Norwegian authorities take this discussion forward with the European Banking Authority to ensure full understanding of how the capital structure in the Norwegian savings banks actually works, and to make the broader consequences of any changes fully clear. And we strongly believe that it is both possible and absolutely necessary to maintain the equity certificate as CET1 capital within the framework of today's regulation. So on behalf of the Norwegian Savings Banks Association, thank you once again for being with us, and I wish you all a very good afternoon. Thank you.
Thank you so much.
Thank you. Bye.
Thank you. Bye.